Are you taking the solicitor's qualifying examination? If so, this video is a practice test question to help you prepare for the SQE1 exam. In this part of the course, we'll cover what you need to know for the SQE1 exam about prohibitions on public assemblies. This forms part of the public law section of the SQE1 exam curriculum. I will explain this in this easy to learn diagram. We will then go through this practice test question together for the SQE1 exam for this topic. To get the first part of our full SQE preparation course for free, just click on the link below. My goal is to help you prepare for and pass the solicitor's qualifying examination first time. Prohibiting trespass-free assemblies is governed by Section 14A of the Public Order Act 1986. Section 14A says if at any time the Chief Officer of Police reasonably believes that an assembly is intended to be held in any district at a place on land to which the public has no right of access, or only a limited right of access, and that the assembly is likely to be held without the permission of the occupier of the land, or to conduct itself in such a way as to exceed the limits of any permission of his or the limits of the public's rights of access, and may result in serious disruption to the life of the community, or where the land or building or monument on it is of historical, architectural, archaeological, or scientific importance, in significant damage to the land, building, or monument, he may apply to the council of the district for an order prohibiting, for a specified period, the holding of all trespass-free assemblies in the district or a part of it as specified. On receiving such an application, a council may, in England and Wales, with the consent of the Secretary of State, make an order, either in the terms of the application or with such modifications as may be approved by the Secretary of State. No order under this section shall prohibit the holding of assemblies for a period exceeding 4 days, or in an area exceeding an area represented by a circle with a radius of 5 miles from a specified centre. Assembly means an assembly of 20 or more persons. So to summarise, if there is to be an assembly, that is an assembly of 20 or more people on land to which there is no right of access or a limited right of access, and it is likely to be held without the permission of the occupier or exceed the limits of permission, and it may result in serious disruption to the life of the community or significant damage to land, a building, or a monument which is of importance in historical, architectural, archaeological, or scientific terms, then an application may be made by the Chief Officer of Police to the Council, and then with the consent of the Secretary of State an order may be made prohibiting the assembly. So with that in mind, here is a sample question of the kind that you may get in the SQE1 exam. There is to be an assembly of 30 people on private farmland without the freeholder's consent against the treatment of animals on a farm there. The police have credible evidence that buildings on the farm, including a historically significant farmhouse, may be badly vandalised during the assembly. What is the correct position in law in relation to the powers of the Chief of Police? A. An application may be made to the council to prohibit the assembly. B. An application could be made to the council only if significant damage had actually been caused by the assembly. C. No application could be made as the farmhouse is not of architectural or archaeological significance. D. There is no power to prohibit the assembly because only 30 people will attend. The answer is A. An application may be made to the council to prohibit the assembly. So let's go through why the other answers are wrong. B. An application could be made to the council only if significant damage had actually been caused by the assembly. Well, no, it is not necessary to show that significant damage has actually been caused. The police can apply before an assembly gathers, i.e. before any damage is done. That's the whole point of the regime. C. No application could be made as the farmhouse is not of architectural or archaeological significance. Well, we know that the farmhouse is of historical importance and that alone is sufficient. So it doesn't matter that it's not of architectural or archaeological significance. D. There is no power to prohibit the assembly because only 30 people can attend. Well, we know from the definition of assembly that the threshold is 20 or more people, so that's sufficient. I hope you found this helpful. To get the first part of our full SQE preparation course for free, just click on the link below. See you in the course.